This is part 55, and in this part we shall be discussing chapter 11 of the Indian Penal Code, dealing with offences of giving false evidence. The heading of the chapter is false evidence and offences against public justice, out of which section 191 defines the offence of giving false evidence. Section 192 defines the offence of fabricating false evidence, and rest of the sections with which we will continue our discussion. Now, if we this is right from section 191 up to 229A of the Indian Penal Code. The chapter is lengthy, no doubt about it, but at the same time, let me tell you that to understand this chapter, during course of time you will learn that when you will understand procedural aspects as far as law is concerned, for example, who has to give evidence? That is, a witness has to depose evidence in a court of law. Now, he may be witness on behalf of the prosecution, he may be witness on behalf of the defense, he may be what is known as court witness as far as criminal law is concerned, or he may be witness on behalf of the plaintiff, he may be witness on behalf of the defendant, or he may be called in the capacity, when we talk about expert evidence, he may be called as an expert also. So whoever may be the person, once he enters the witness box, then it is must for him that he has to depose evidence, and whatever he tells must be true. If that is not done by him, what is his liability? Or if you create any circumstance to exist, and then because of which somebody other is likely to be punished for whatever is done by you, or you deliberately do it, that is what is known as fabricating false evidence. But this can be to a certain extent. I shall be giving the illustrations which are given in the book zone. If needed, we will give some other illustrations, no doubt about it. But otherwise, concentrate by reading the illustrations. And let me tell you one thing. During course of time, as you go on understanding the provision, namely procedural aspect of law, then only it will be possible for you to have grasp or these offences with which you have started discussing right from section 191 up to 229A, capital A of the Indian Penal Code. Now section 191 defines the offence of giving false evidence, and it says, whoever being legally bound by an oath or by an express provision of law to state the truth, or being bound by law to make a declaration upon any subject and makes any statement which is false. So what the person makes a statement which is false, and which he either knows or believes to be false, or does not believe it to be true, is said to give false evidence. So this is person. Whoever being legally bound, the person must be legally bound by law, by an oath or by an express provision of law to state the truth. That is the requirement, that he has to state the truth. Or being bound by law to make a declaration upon any subject and makes any statement which is false, and which he either knows or believes to be false, or does not believe it to be true, is said to give false evidence. Explanation 1 to the section says, a statement is within the meaning of this section, whether it is made verbally or otherwise. So it may be made verbally, or it may be made in writing, or otherwise also. Explanation 2 says, a false statement as to the belief of the person attesting it is within the meaning of this section, and a person may be guilty of giving false evidence by stating that he believes a thing which he does not believe, as well as by stating that he knows a thing which he does not know. So these are the aspects which are covered as far as this section is concerned. Now, the illustration, if you have start going through some of the illustrations, it says, A, in support of just claim which B has against Z for 1000 rupees. Now what he says, A falsely swears on a trial that he heard Z admit the justice of B's claim. So here, and A has given false evidence. A, being bound by an oath to state the truth, states that he believes a certain signature to be handwriting of Z when he does not believe it to be the handwriting of Z, when A states that which he knows to be false and therefore gives false evidence. If a witness is in a witness box, during course of time you will learn that he has to undergo what is known as examination in chief by the party who calls him, cross-examination by the opposite party, and then what is known as re-examination. If he makes one statement, now one statement as far as examination is chief is concerned, and exactly contrary statement as far as cross-examination is concerned, naturally one of the statement is false, or one of the statement can only be true, and hence what is his liability? Such a person is liable for the offence of giving false evidence as defined by section 191 of the Indian Penal Code. Now, sometimes a person may be appointed as an interpreter also, and then an interpreter or translator gives or certifies as to true interpretation or translation of a statement or document which is bound by law to interpret or transfer truly, and that which is not and which he does not believe it to be true interpretation or translation, A has given false evidence. So in a court of law, as far as when you shall be dealing with criminal law, you will come across section 279 of the Criminal Procedure Code, which deals with interpreter. If a person who is in the witness box doesn't understand the proceedings which are going on in a court of law, then you appoint a person who knows his language and also the language of the court. So the question which is put to him can be interpreted by him, and the answer which is given by him can also be interpreted by him. Now, if he doesn't do that job correctly, in the sense if he has not done what a statement is made and he has interpreted or translated it wrongly or falsely, then he is liable as far as the offence of giving false evidence is concerned as defined by section 191. So, whoever being legally bound by an oath or by an express provision of law to state the truth, or being bound by law to make a declaration upon any subject, makes any statement which is false and which he either knows or believes to be false or does not believe it to be true, is said to give false evidence as far as section 191 is concerned. Now section 192, it says, start with the illustration that is given. A puts jewel into box belonging to Z with the intention that they may be found in that box and that this circumstance may cause Z to be convicted of theft. A has fabricated false evidence. A makes a false entry in his shop book for the purpose of using it as a corroborative evidence in a court of justice. A has fabricated false evidence. A, with the intention of causing Z to be convicted of criminal conspiracy, writes a letter in intimation of Z's handwriting purporting to be addressed to an accomplice in such criminal conspiracy, and puts the letter in a place which he knows that the officer of the police are likely to search. A has fabricated false evidence. So what is now section 192 of the Indian Penal Code defines the offence of fabricating false evidence, and it says, whoever causes any circumstance to exist or makes any false entry in any book or record or electronic record, or makes any document or electronic record containing a false statement, intending that such circumstances, false entry or false statement may appear in evidence in a judicial proceeding or in a proceeding taken by law before a public servant as such, or before an arbitrator, and that circumstance, false entry or false statement so appearing in evidence may cause any person who in such proceeding is to form an opinion upon the evidence, to entertain an erroneous opinion touching any point material to the result of such proceeding, is said to fabricate false evidence. So that is as far as section 192 is concerned, which deals with, as I told you, if you go through the illustrations which are given, it becomes very easy for you to understand section 192, which defines the offence of fabricating false evidence. Now 133 deals with punishment for false evidence, and it says, whoever intentionally gives false evidence in any stage of a judicial proceeding or fabricates false evidence for the purpose of being used in any stage of judicial proceeding shall be punished with imprisonment of either description for term which may extend to 7 years and shall also be liable to fine. And whoever intentionally gives or fabricates false evidence in any other case shall be punished with imprisonment of either description for term which may extend to 3 years and shall also be liable to fine. The explanation to the section says, 1. Explanation 1. A trial before a court martial is a judicial proceeding. Explanation 2 says, an investigation directed by law preliminary to the proceedings before a court of justice is a stage of judicial proceeding, though that investigation may not take place before a court of justice. Explanation 3 says, an investigation directed by a court of justice according to law and conducted under the authority of a court of justice is a stage of a judicial proceeding, though that investigation may not take place before a court of justice. So this is as far as the section 193 is concerned. Section 194, giving or fabricating false evidence with intent to procure conviction of a capital offence, and says, whoever gives or fabricates false evidence intending thereby to cause or knowing it to be likely that he will thereby cause any person to be convicted of an offence which is capital by law for the time being in force in India shall be punished with imprisonment for life or with rigorous imprisonment for term which may extend to 10 years and shall also be liable to fine. And if innocent person be thereby convicted and executed, and if an innocent person be convicted and executed in consequence of such false evidence, the person who gives such false evidence shall be punished either with death or the punishment herein before described. Section 195, giving or fabricating false evidence with intent to procure conviction of offence punishable with imprisonment for life or imprisonment, and says, whoever gives or fabricates false evidence intending thereby to cause or knowing it to be likely that he will thereby cause any person to be convicted of an offence by which by the law for the timing in force in India is not capital but punishable with imprisonment for life or imprisonment for term of 7 years or upward shall be punished as a person convicted of that offence would be liable to be punished. Section 195 capital A, threatening any person to give false evidence, and it says, whoever threatens another with any injury to his person, reputation or property, or to the person or reputation of anyone in whom that person is interested with intent to cause that person to give false evidence shall be punished with imprisonment of either description for term which may extend to 7 years or with fine or with both. And if innocent person is convicted and the sentenced in consequence of such false evidence with death or imprisonment for more than 7 years, the person who threatens shall be punished with same punishment and sentence in the same manner as to the same extent such innocent person is punished and sentenced. Section 196, using evidence known to be false, and it says, whoever corruptly uses or attempts to use as true or genuine evidence any evidence which he knows to be false or fabricated shall be punished in the same manner as if he gave or fabricated false evidence. Section 197, issuing or signing false certificate. It says, whoever issues or signs any certificate required by law to be given or signed or relating to any fact of which such certificate is by law admissible in evidence, knowing or believing that such certificate is false in any material point, shall be punished in the same manner as if he gave false evidence. Section 198, using as a true a certificate known to be false, and say, whoever corruptly uses or attempts to use such a certificate as a true certificate, knowing the same to be false in any material point, shall be punished in the same manner as if he gave false certificate. Section 199, false statement made in declaration which is by law receivable as evidence, and says, whoever in any declaration made or subscribed by him, which declaration any court of justice or any public servant or other person is bound or authorized by law to receive as evidence of any fact, makes any statement which is false and which he either knows or believes to be false or does not believe it to be true, touching any point material to the object for which the declaration is made or used, shall be punished in the same manner as if he gave false evidence. Section 200. Using as true such a declaration knowing it to be false, and says, whoever corruptly uses or attempts to use as true any such declaration knowing the same to be false in any material point shall be punished in the same manner as if he gave false evidence. And the explanation to the section says, a declaration which is inadmissible merely upon the ground of some informality is a declaration within the meaning of section 199 and 200. Section 201. Causing disappearance of evidence of offence or of giving false information to screen offender, and says, whoever, knowing or having reason to believe that an offence has been committed, causes any evidence of the commission of that offence to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offence which he knows or believes to be false, if a capital offence shall, if the offence which he knows or believes to have been committed is punishable with death, be punished with imprisonment of either description for term which may extend to 7 years and shall also be liable to fine. If punishable with imprisonment for life, and if the offence is punishable with imprisonment for life or with imprisonment which may extend to 10 years, shall be punished with imprisonment of either description for term which may extend to 3 years and shall also be liable to fine. If punishable with less than 10 years imprisonment, and if the offence is punishable with imprisonment for any term not exceeding to 10 years, shall be punished with imprisonment of either description provided for the offence for a term which may extend to 1/4 of the part of the longest term of imprisonment provided for the offence, or with fine or with both. Section 202. Intentional omission to give information of offence by person bound to inform. It says, whoever, knowing or having reason to believe that an offence has been committed, intentionally omits to give any information respecting that offence which is legally bound to give, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine or with both. Now this section, this section can be correlated with that of section 176 of the Indian Penal Code, with which you are dealt. When a person is bound by law to give information, and if it is not given by him, and to be correlated with what? To be correlated with section 39 of the Indian Penal Code, to which I had drawn your attention as far as criminal procedure code is concerned during the course of discussing section 176 of the Indian Penal Code. With this, now section 203, giving false information respecting an offence committed. Now if somebody gives giving false information, section 177, to which I had referred to, he said, whoever, knowing or having reason to believe that an offence has been committed, gives any information respecting that offence which he knows or believes to be false, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine or with both. Explanation. In this section, at section 200 in section 201 and 202, and in this section, the word offence includes any act committed at any place out of India, which if committed in India would be punishable under any one of the following sections, namely, and the list is enumerated accordingly. With this, now section 204, destruction of document to prevent its production as evidence, and it says, whoever secretes or destroys any document or electronic record which he may be lawfully compelled to produce as evidence in a court of justice, or in any proceeding lawfully held before a public servant as such, or obliterates or renders illegible the whole or any part of such document or electronic record with the intention of preventing the same from being produced, or used as evidence before such court or public servant as aforesaid, or after he shall have been lawfully summoned or required to produce the same for that purpose, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. Section 205. False personation for purpose of act or proceeding in a suit or prosecution. And it says, whoever falsely personates another and in such assumed character makes any admission or statement, or confesses judgment, or causes any process to be issued, or becomes bail or security, or does any other act in any suit or criminal prosecution, shall be punished with imprisonment of either description for term which may extend to 3 years, or with fine, or with both. Section 206 deals with fraudulent removal or concealment of property to prevent seizure as aforesaid or in execution. Whoever fraudulently removes, conceals, transfers, or delivers to any person any property or any interest therein, intending thereby to prevent that property or interest therein from being taken as a forfeiture, or in satisfaction of a fine, under a sentence which has been pronounced, or which he knows to be likely to be pronounced by a court of justice or other competent authority, or from being taken in execution of decree or order which he has made, or which he knows to be likely to be made by a court of justice in a civil suit, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. Section 207 says, fraudulent claim to property to prevent its seizure as forfeited or in execution. Whoever fraudulently accepts, receives, or claims any property or any interest therein, knowing that he has no right or rightful claim to such property or interest, or practices any deception touching any right to any property or any interest therein, intending thereby to prevent that property or interest therein from being taken as a forfeiture, or in satisfaction of fine, under a sentence which has been pronounced, or which he knows to be likely to be pronounced by a court of justice or other competent authority, or from being taken in execution of a decree or order which has been made, or which he knows to be likely to be made by a court of justice in a civil suit, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. Section 208. Fraudulently suffering decree for sum not due. Whoever fraudulently causes or suffers a decree or order to be passed against him at the suit of any person for a sum not due, or for a larger sum that is due to such person, or for any property or interest in property to which such person is not entitled, or fraudulently causes or suffers a decree or order to be executed against him after it has been satisfied, or for anything in respect of which it has satisfied, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. Section 209. Dishonestly making false claim in court. It says, whoever fraudulently or dishonestly or with intent to injure or annoy any person makes in a court of justice any claim which he knows to be false, shall be punished with imprisonment of either description for term which may extend to 2 years, and shall also be liable to fine. Section 210. Fraudulently obtaining decree for sum not due. And it says, whoever fraudulently obtains a decree or order against any person for a sum not due, or for a larger sum than it is due, or for any property or interest in property to which he is not entitled, or fraudulently causes a decree or order to be executed against any person after it has been satisfied, or for anything in respect of which it has been satisfied, or fraudulently suffers or permits any such person to be done in his name, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. With this, Section 211. False charge of offence made with intent to injure, and says, whoever with intent to cause injury to any person institutes or causes to be instituted any criminal proceedings against that person, or falsely charges any person with having committed an offence, knowing that there is no just or lawful ground for such proceeding or charge against that person, shall be punished with imprisonment of either description for term which may extend to 2 years, or with fine, or with both. And if such criminal proceeding be instituted on a false charge of an offence punishable with death, imprisonment for life, or imprisonment for 7 years, or offer, shall be punishable with imprisonment of either discretion for term which may extend to 7 years, and shall also be liable to fine. With this, Section 212 deals with harboring offenders. Whoever an offence has been committed, Section 212 harboring offender says, whenever an offence has been committed, whoever harbors or conceals a person whom he knows or has reason to believe to be offender with the intention of screening him from legal punishment, if a capital offence, shall, if the offence is punishable with death, be punished with imprisonment of either description for term which may extend to 5 years, and shall also be liable to fine. If punishable with imprisonment for life, or with imprisonment, and if the offence is punishable with imprisonment for life, or with imprisonment which may extend to 10 years, shall be punished with imprisonment of either description for term which may extend to 3 years, and shall also be liable to fine. And if the offence is punishable with imprisonment which may extend to 1 year and not to 10 years, shall be punished with imprisonment of either description provided for the offence for a term which may extend to 1/4 part of the longest term of imprisonment provided for the offence, or with fine, or with both. Offence in this section includes any act committed at any place out of India, which, if committed in India, would be punishable under any of the following sections, namely, and the sections are enumerated, and every such act shall, for the purposes of this section, be deemed to be punishable as if the accused person had been guilty of it in India. Exception says, this provision shall not extend to any case in which the harbor or concealment is by husband or by wife of the offender. Section 213, taking gift, etc. to screen an offender from punishment, and says, whoever accepts or attempts to obtain or agrees to accept any gratification for himself or for any other person, or any restitution of property to himself or any other person in consideration of his concealing an offence, or of his screening any person from legal punishment for any offence, or of his not proceeding against any person for the purpose of bringing him to legal punishment, if a capital offence, shall, if the offence is punishable with death, be punished with imprisonment of either description for term which may extend to 7 years, and shall also be liable to fine. If punishable with imprisonment for life, or with imprisonment, and if the offence is punishable with imprisonment for life, or with imprisonment which may extend to 10 years, and also shall also be punished with imprisonment of either description for term which may extend to 3 years, and shall also be liable to fine. And if the offence is punishable with imprisonment not exceeding to 10 years, shall be punished with imprisonment of description provided for the offence for a term which may extend to 1/4 part of the longest term of imprisonment provided for the offence, or with fine, or with both. With this now, we have to continue up to section 229, and hence right from section 214 onward we shall be continuing as far as next part is concerned.